Think about this scenario for a moment. You're exhausted. You've been fighting, or maybe worse, avoiding the fight for months. The paperwork is piling up. The constant tension in your home is suffocating, and all you crave is peace. You just want this whole nightmare to be over. Then, one day, your soon-to-be ex's lawyer sends over a document. It's thick, it's intimidating, and it's called a marital settlement agreement. Your lawyer tells you, it's a decent offer. We can push for more, but that means more time, more fees, more stress. And in that moment of utter desperation, the desire for a quick end, for that beautiful, elusive peace, feels overwhelming. You're ready to just sign on the dotted line and walk away. But what if signing it today meant trading short-term relief for long-term regret? What if it contained a blind spot, a future consequence you're too emotionally drained to see right now that could cost you your financial security, your retirement, or critical time with your children years down the line? You are not alone in feeling this pressure. Every single person going through divorce reaches this breaking point. But I'm here to tell you, from the bottom of my heart, that this is the single most important document in your divorce. And rushing to sign, it is the single most common and most costly mistake people make. Do not sign that settlement agreement until you watch this video. Welcome to my channel. I'm dedicated to helping you move through your divorce with less stress, more clarity, and the quiet confidence that you are creating a healthier, happier future. Today, we are tackling the marital settlement agreement, MSA, sometimes called a stipulated judgment or a divorce agreement. This isn't just paperwork. It is the blueprint for your entire post-divorce life. It dictates everything: how you will divide a lifetime of assets, who lives where, how much you will pay or receive, and perhaps most importantly, how your relationship with your children will be structured for the next decade. The pain points are clear. You feel overwhelmed by legal language. You worry about being taken advantage of. You are terrified of missing a crucial detail that will haunt you later. Here's my promise to you. By the time you finish this video, you will no longer look at that agreement as a paralyzing threat. You will see it as your roadmap and your control panel. We will break down the 5 critical, non-negotiable areas you must scrutinize, and I will give you the emotional and practical tools to pause, think clearly, and negotiate from a place of strength, not desperation. This knowledge is your power. Let's dive in. When people think about dividing assets, they focus on the house, the savings, the retirement accounts. But one of the most dangerous and often overlooked areas is debt and liability. You must understand that a divorce decree does not automatically override a creditor. Here's a realistic example. Let's say the agreement assigns the joint credit card debt to your ex-spouse. That's great, right? Not necessarily. If your name is still on that credit card account and your ex-spouse fails to make the payments, even a year from now, the credit card company can still come after you. Your credit score will plummet, and you'll be legally on the hook for a debt you thought you left behind. The actionable thing to do: insist that the agreement specifies one of 2 things for every joint debt. A, the responsible party refinances the debt into their name alone within a specific, short time frame, say 90 days, or B, the asset associated with the debt, like a car or the home, is sold and the debt is paid off immediately. Do not simply rely on a promise to pay. It's okay to feel suspicious about this. You're not being petty. You are being responsible for your future. This is not about trusting your ex. This is about protecting yourself from a financial disaster years down the road. You deserve to walk away with a clean, protected credit report. This is where the simple language ends and the vital legal steps begin. For many people, retirement accounts, that is the 401k, the pension, the IRAs, are the second most valuable asset, second only to the house. If you're entitled to a portion of your spouse's retirement, the MSA is not the end of the process. It's just the beginning. Your agreement should state exactly what percentage or dollar amount you receive. But here is the critical part that most people miss. The judge's signature on the divorce decree is not enough to transfer retirement funds. You need a special, separate legal document called a Qualified Domestic Relations Order, or a QDRO. Pronounced QDRO. This document is what the retirement plan administrator, like Fidelity or Vanguard, actually needs to legally split the account without triggering massive tax penalties. Realistic example. I've seen situations where the divorce was final, the agreement was signed, and then the party who was supposed to receive the funds realized a year later that the QDRO was never submitted. In some cases, the ex-spouse had passed away, or the funds were spent or moved, making it incredibly complex or even impossible to recover the entitled amount. The actionable thing to do. Your settlement agreement must clearly state who is responsible for drafting, submitting, and paying for the QDRO. It should also specify a deadline, like the QDRO shall be entered within 120 days of the judgment of divorce. This is non-negotiable. Don't just agree to a split, agree to the mechanism for the split. For those with children, the parenting plan section is the beating heart of your agreement. Every other part of the divorce is about money. This is about your kids' well-being and your continued role as a parent. We need to move beyond vague phrases like reasonable visitation. You need granular detail to prevent future conflict. What does the agreement say about the mundane, everyday friction points? 1. Transportation. Who handles the drop-off? Who handles the pickup? Where do exchanges happen? 2. Holidays. Does it clearly define spring break? Is it always the first week of the public school break? Or does it alternate? Spell out every single holiday, down to Mother's Day and Father's Day. 3. Relocation. What is the specific distance, e.g. 50 miles? One parent can move before needing the other parent's written consent or a court order. You are building a fence of protection around your children. Every argument you have now about a holiday schedule is an argument you won't have in front of your children next December. By being detailed, you are actually introducing more peace into their lives. You are trading short-term conflict over details for long-term predictability and stability for your kids. The actionable thing to do. Do not settle for ambiguity. Create a detailed, month-by-month calendar attachment to the agreement. Demand specific language on communication, e.g., response time for non-emergency emails, 48 hours, and who holds the children's passports and medical documents. This section, particularly for divorces finalized after the 2018 tax reform, is absolutely critical. Prior to 2019, alimony was generally tax-deductible for the payer and taxable income for the recipient. That is no longer the case for new agreements. For most agreements signed today, the payer cannot deduct the spousal support payments, and the recipient does not count it as taxable income. Why does this matter? Because the net financial impact on both parties is dramatically different, and it must be factored into the overall amount. You cannot simply agree to the amount based on old assumptions. You need to run the numbers using the new tax implications. A financial divorce analyst or a well-versed attorney can do this. A $2,000 monthly payment might look good on paper, but the true cost of the payer is much higher now that they can't deduct it. The true benefit to the recipient is also different because they don't have to pay taxes on it. Ensure the number reflects the actual post-tax reality for both parties. The actionable thing to do. Explicitly confirm with your attorney how the agreed-upon spousal support payments are treated for federal and state tax purposes and that the agreement language reflects this understanding. Do not assume your ex-spouse agreement is based on the current tax law. Finally, let's talk about the nightmare scenario. What happens when the agreement is signed, the ink is dry, and your ex simply doesn't comply? They refuse to turn over the car title. They stop paying the insurance premium they agreed to cover. A settlement agreement is only as strong as its enforcement mechanism. A poorly written clause here means you'll be constantly dragged back to court, spending thousands just to force your ex to do what they already promised. Your agreement should have teeth. Specifically, look for a clause that addresses attorneys' fees for enforcement. The actionable thing to do. The agreement must state that if one party has to go to court to compel the other to follow the terms of the agreement, For example, to force the sale of a house or recover a past due payment. The non-compliant party will be responsible for the legal fees and costs incurred by the compliant party. This clause is a powerful deterrent. It essentially says, if you make me go back to court over this, you're going to pay for both of our lawyers. This one clause can save you tens of thousands of dollars and countless hours of stress down the road. Take a deep breath with me. I know this feels like a marathon of stress, legal complexity, and fear. You might be watching this with a signed but not filed agreement on your kitchen table, and you're feeling a surge of anxiety, wondering if you missed something. It is absolutely okay to feel overwhelmed, but I want to shift your perspective right now. You're not being difficult by demanding clarity. You're not being aggressive by asking for protection. You are simply doing the hard, necessary work of building a foundation for your new life. A foundation that is secure, stable, and protected. Divorce is the painful ending of a chapter, but the settlement agreement is the absolute first page of your brand new book. Think of it not as a compromise, but as a sacred contract with your future self. It's the document that gives you permission to stop worrying about what your ex might or might not do, and to start focusing 100% on your own healing, your own growth, and your own happiness. You have survived the hardest parts already. You are strong enough to read the fine print. You are smart enough to ask the tough questions. Don't let your current emotional exhaustion rob your future self of the security and peace you deserve. Take your time, get good counsel, and remember that by being meticulous now, you are buying peace for a decade. You got this. If this video gave you just one piece of clarity, one moment of calm, or one actionable step you can take today, please do two things for me. First, hit that like button. It tells the algorithm that this content is helping people, and it helps us get this vital information to others who are feeling just as lost as you might be right now. Second, I want you to join the conversation below. In the comments, tell me, which of these 5 sections are you most concerned about right now? Is it the debt, the QDRO, the parenting plan? Share your thoughts. We are a supportive, non-judgmental community here, and reading others' experiences can be incredibly validating. You're building a better future, one careful step at a time. I'll see you in the next video. Take care of yourself. God bless you.